you by Robert and Sons. Seeing is believing. And Dr. Okoboy, Bernard Okoboy, has left us. And Gary Nemako Mafo, member, Legal and Constitutional Committee of the New Patriotic Party, joins us. Thank you, Gary, for joining us.
Thank you, my brother.
Great. So we're hoping that we would have a lot of time, but we have a very constrained time. So let's see how we are able to go about it, beginning with Dominic Ayine. So we are in the court, and now the media report, as we see, is that you are saying that your petition should stop. Is that really what is going on?
I think that is a layman's conception of what is happening. But of course, as lawyers, we do know that at some point in time when, you know, there is a preliminary or interlocutory matter that is before the court, you can apply for proceedings to be stayed, which means that the court will not continue with the trial until that matter is determined, because in your view, that matter is so important to the trial itself, to the main trial itself, that you think that it should be determined before the trial goes. And in our case, it's because we have a review application that has been filed before the court, in which we are asking the court to take a second look at its ruling of the 19th of January that refused our application for interrogatories. Because we are saying that if you take the date that was fixed for the review, which is the 28th, you know, of January, all right, it is beyond the date of the trial. The trial is supposed to start on the 26th. And if supposing for the sake of argument that the Supreme Court, you know, takes a second look at this, you know, 19th January decision and comes to the position that it was wrong, and which we think it was, and now says that we can administer the interrogatories, which are the set of questions that we want the Electoral Commission to answer, then it will mean that we will have to take about 2 or 3 steps backwards. All right, have the Electoral Commission answer the interrogatories for us to then incorporate them into our evidence, because you know that once they have been answered and filed, they are deemed admitted, okay, and they will form part and parcel of our evidence going forward, so that if we now have to revise our witness statements or some other documents that we're supposed to, file, then we'll have to do that before we come back to the court. And so that is why we ask the court to stay proceedings pending the determination of the application for review. Okay, so, but I myself have been receiving calls from lay people saying that you brought a petition and you are now saying that the court should halt and not determine the petition. But that is as a result of the PR machinery of our opponents, who are seeking to make it look like we are, not in control of what is happening in court. But of course, something you do know that the NDC as a party and President Mahama as the petitioner has put, our best foot forward. I mean, there are few lawyers as smart as Mr. Chachuchikata in this country and as experienced as he is. So the whole notion that, a legal guru of his stature does not know what he's about, even if Tachu doesn't know what he's about, at least, Dr. Ayine knows what he's about. I taught Gary Nimako, I taught the Deputy Attorney General and so on. They cannot tell me that I do not know basic, courtroom procedure pursuant to CI 16. I have practiced before the Supreme Court, consistently for many years. There's no reason why anybody should give the impression that we are not knowledgeable of the procedures, we don't know what is happening, we are not prepared and so on.
Yeah.
In fact, we are super prepared, and they are afraid that if we go down the route that we want,
the complaints, the complaints, and as we hear the MPP team say, is that you seem to know you don't have a good case, and so you are just trying to put, stumbling blocks in the way to delay this process unnecessarily, when the court has a 42 days timeline.
42 days.
I have in my hand a practical guide to civil procedure in Ghana, written by one of the judges, Samuel Mafo-Sao. And when it comes to what you're seeking to do, this is what you have been raising in the court. Basically, he says that this is a process which a party in an action may compel the disclosure of important documentary evidence in possession of the opponent to enable the party prepare sufficiently for the trial. Essentially, it is one of the pre-trial protocols offered by the rules to promote early disposal of cases. Now, discovery, interrogatories is one of discoveries. But you see, in this book, which he eloquently explains the process, he makes the point that what you are seeking must be relevant.
Yes.
Otherwise, the court, according to the rules, will not grant you.
That is so.
The court says what you are seeking is not relevant. That's why they've denied you.
Well,
why are you still going back with a review instead of proceeding to file your witness statements, file your arguments for the preliminary issue, and then the case can go on?
It's something, the statement that what we are seeking, from the, the Electoral Commission is not relevant, is patently false. It's false because if you watch proceedings that day, Mr. Chikada took time to take the court through all the 12 questions that he had, filed to be administered to the, to the Electoral Commission, the first respondent. Then also, and very importantly, the lawyer for the Electoral Commission, my own good friend, Justina Menuvo, all right, and, on his feet, said that the answers we are seeking are found in their answer, all right, which means that they are relevant to be they are relevant to the process. Okay, he didn't say that nothing has been said in the pleadings regarding the questions we are asking. He said the answers are found in the answers filed by the respondent. So why are we seeking these answers? But of course, if you have a very terse paragraph or two dealing with a matter, a party is at liberty to file interrogatories, to ask you to expatiate, to ask you to provide more information for purposes of the conduct of the litigation.
Now you have as many as 7 judges.
Yes.
All of them come to one mind.
Yes.
That what you are saying is relevant, it's not relevant.
No.
And again, as we understand, you have the opportunity to raise these matters in the trial by way of cross-examination. Yeah. Why don't you do that?
But you very well know that under cross-examination, all right, when you ask a question, it can be overruled. All right, so cross-examination as a mechanism for putting that information forward is weaker than the administration of interrogatories, because once the answers have been provided by the respondent and filed, they are deemed admitted. So it is very, very important for us, to have these, answers. You see, what the respondents did, okay, especially the first respondent, was basically to narrate how they complied with the law, right? By just taking the law itself and narrating the procedure. Our questions are designed to find out, in actual fact, what happened. That is very important.
So until they hear the review and give you their decision, you are not filing your witness statements and your preliminary arguments?
Because we have filed for stay of proceedings.
Okay.
Yes. So that is the effect.
If you have filed for stay, but the stay has not been heard yet.
Yes, the stay will be heard. If it is granted, of course, we will not be required to immediately file our witness statements. However, if it is not granted, then it means that the trial will proceed as planned. But there is something that I wanted to bring to your attention. Okay. You have just read.
Get that quickly.
Yeah, you've just read the the portion from Justice Mafo-Sao's book where he says that interrogatories are designed in order to
achieve speed.
To achieve speed. Okay, so basically that is the constitutional or statutory basis of interrogatories. And I just wanted to refer you to the case of Abubakar and Yardua, all right, in which the Nigerian Supreme Court actually said that a denial of the right to file interrogatories, to administer interrogatories, is a denial of justice and a violation of the constitutional principle of a fair trial. That is very important.
Then why does the law make it a discretionary thing in the rules, so that a judge must consider all the factors to come to the conclusion that what you are asking is germane, is relevant before they give it?
It's something. It is good that Dr. Ine, at least, has taught some of us law. And I think it's credit to him that some of his students are petitioners before the courts of Ghana. You see, like the justices said, the grant of interrogatories, clearly, it is very clear. It has to be relevant to the issues in contention. Now, if you look at the questions that were raised before the court, 7 judges, not even one dissented, said the questions that you were asking is not relevant to the issue before the court. Now, Samson, look at the rules that the court is now using to apply now, the CR 99, which was spearheaded by the Honorable Mrs. Marita Brew appeal upon.
No, she didn't. She didn't.
So who spearheaded it?
No, the Rules of Court Committee did. She was just a member of the Rules Committee of Court Committee.
Fine.
Yeah.
And at that time, in 2016, I think this was post-election petition 2013.
That's right.
Where President Mahama made it very clear that election petition for 8 months clearly affected his governance. Now, the essence of this year 99, if you look at it carefully, is expedition. It doesn't also mean that when the court is administering expeditious trial, the court will throw away all issues of substance and justice and then say, well, we're not going to deal with all procedures, we're not going to deal with interrogatory, we're not going to do with anything, but rather we are just simply saying that, come along, whatever it is, we are going to deal with the matter within 42 days. That's not the matter. Mm-hmm. What is happening now is that in the course of dispensing justice, in the course of hearing the petition which you have brought before the court must be guided by the application of CR 99. Now, do we really have a question in terms of the legibility of the election before the court, so to speak?
No.
Validity. So to speak.
That's a different matter.
Yeah. Let me take us through.
Different matter altogether.
You see,
right.
you see something. All the questions, you know, a very important question. All the questions which they seek to ask Mrs. J. Mensah, they can be posed to her during the cross-examination. Now, you say it can be overruled. It can only be overruled if the question is not relevant to the matters in contention. Mm-hmm. How can a matter or an answer which is relevant to the trial be overruled by the court? Mm-hmm. It's not possible. It is only when it's not relevant to the issue that it can be overruled.
Do you then see a certain danger?
Yes.
If asking it now is irrelevant, then asking it later, will that be relevant?
No, if in your view they say it's relevant to the issue, and therefore they file for review, my position is that question can be put through the witness, and he has filed a witness statement. And clearly it means that Mrs. J. Mensah is going to enter the box herself.
No, this is the question I'm asking.
Yes.
Practically what they are seeking to do now, you are saying they can do it later.
If they find it relevant.
Right.
In their view.
If instead of
going to the route, if
it is held to be irrelevant.
Instead of going to the route,
today, will it be relevant?
Instead of going to the route, no, they are saying that in their view. You see, you can put 10 lawyers in the room. 5 may agree, 5 disagree. I'm saying that if in their view, respectfully, my professor finds that position relevant, and for that reason they file for review, in application determined by 7 justices, and they all said that, look, it is without merit, so we have thrown it away. In a review application, what manifest error has occasioned? To the extent that you can say that all the 7 justices, at least some or all, will change their mind.
Let's be careful not to determine that.
No, I'm just saying 7-0. Because now they're going to bring 2 to make it 9.
2 more. Yes.
So the 9
anything can happen. You know, judges can change their mind after they have done. You know, even in the High Court, when we do a process, we can go back for a review before the same judge, and they will change their mind. You've done that.
Yeah, but review now, I'm taking it from the High Court rules.
No, I know, but I'm telling you that
it's no longer within the High Court rules.
What I'm saying is to give you an example that a judge, you and I have appeared before judges. They give a decision, and then we point out to them that they have made some error here or something, okay? and then we go back to the same judge within 7 days, and they change their decision.
That is the single judge?
Yes, single judge.
This one, 7 justices, you mean none of them got it right?
Yes, I mean...
None of them got it right, the 7 justices?
In a number of decided cases, which we have referred to copiously in our review application, the Supreme Court is, in even situations where it has unanimously rendered a decision, okay, has, reversed itself upon review.
Okay. Please,
so Doc, let's see how it goes. Okay. I see clearly something. There is a matter where I find so curious. We went through elections. In the elections, we were not told that prior to the ballot box being open, or when it was open, people are putting materials in there. We were not told that in the counting processes, somebody has altered some figures anywhere. We are not told that in the collation processes, something unruly has been meted to anybody.
We were told that.
Well, yeah.
In the collation processes?
Yes, we were told.
In the collation?
Yes.
Yeah. The presidential.
And I think that is where you people are afraid.
No, let him finish. Yeah.
You see.
but you know something, Gary? In the 2013 petition, if you read the judgments, there were matters that the NPP, as in Nanado and his colleagues, raised, but they abandoned during the trial, like padding and other issues. They abandoned them during the trial. So is it not fair to allow a party to raise their issue and proceed? Let's see how it ends.
You can raise the issue. That is the reason why they must allow the trial process to go on. It should go on. Now the issues have already been raised. 5 issues, I believe.
Yes.
Yes, 5.
And the roadmap has been drawn up.
But to us, it's a wrong roadmap.
Well, if it's a wrong roadmap, whatever it is,
and a very unfair roadmap.
You said that you have filed a review application, and then filed for a stay of proceedings pending the hearing of your review and the determination of your review,
which is on the 28th.
On the 28th. So we will wait and let the court, the 7 justices now add 2 to make it 9, and then come and deal with the review.
Yeah.
And then they stay, and then we see how it goes.
Right. But let me bring in Clara.
Yes.
Clara, I don't know what you have to say about this aspect of what has transpired in the courtroom. But in addition, the John Mahama team's complaint is that when you are doing a case management conference, lawyers are supposed to make inputs. But in this case, the judges just took their memorandum of issues, sat in the closet, agreed, and came forward and imposed everything on them. Are they right by suggesting that this is unheard of?
Samson, when it comes to, because there's a review application in court and also a stay of proceedings application in court that is yet to be heard, I would hold my comments on that until the rulings are given.
Okay, so the procedure...
Because these are matters that are being contested. I must say that
what is being contested? What is being contested? Clara, what is being contested is not the directions, the case management. I'm asking you the question about the case management, where they say that case management conferences, as we know, standard, lawyers contribute, and they were not given the opportunity to contribute as to anything. And I'm asking the question, is it unheard of that, particularly in the Supreme Court, that the court itself cannot look at your memorandum of issues and come and tell you these are the ones we have picked, these are the ones we have merged or we have tweaked, and this is the number of days you use, go and bring your witness statement without consulting with you? Is it unheard of?
Samson, it would be unfair to say a yes or no whether something is unheard of, because to be fair to all sides, when you are doing a case and you are in court, it is your satisfaction or complaint is not whether what has happened is unheard of or not, but is whether or not what has happened in court should have happened or not shouldn't have happened. So I wouldn't want to comment right at the moment on whether it is unheard of or it is not unheard of, because I don't think there's value to. It's always like when somebody asks me, can I go to court and say this? And I'm always like, of course you can go to court and say anything you like. It is whether what you have said is something that should be taken or not be taken is the issue, but not whether or not you can say of. So whether it's unheard of or not, it's not for me. It's not
Mareta Brewer-Appiah,
the circumstances in this particular case with this fact, what would have been the best thing to do?
Mareta Brewer-Appiah, who is with the John Mahama team, granted an interview and asked the question, which Dominic Ayene also sort of confirmed to the media. She asked the question, according to the timelines, the schedule provided by CI99, there are 2 days for case management.
5 days, actually.
5 days for the case management conference. So they asked the question, what is the hurry? What do you say about that? Because they feel that if it's case management, the law allows them 5 days.
Well, again, that is still, if you are looking at that, doesn't really answer much. It's not an issue of what is the hurry or what is not the hurry. Of course, if we are going to, are we within the rules? Does it aid the process if we do this? Those are some of the things that we look at. But no, I didn't listen to her interview, I should say. But then again, like I said, I don't really think that
you know,
me commenting on such a comment would have any value on the discussion, because there's more to it. There are more nuances than what appears.
Okay.
When trial is being done in the open like this, where it's on TV, I'm always, should I say, sympathetic to all lawyers, because you are never it's not very easy for either lawyer in this case. You take instructions for your client, nobody knows what the instructions you hold, but everybody thinks of how the case should be handled. It is only you who know the complete set of facts you are working with, what your client's instructions are, and you are doing it to the best of your ability. So when it comes to this, I really want to make any comment that seems as if I'm second guessing any lawyer on any of the teams. I would rather wait for the processes to come, because what helps the process is at the end of the day, when the ruling comes from the court, we are all entitled to comment on the ruling and criticize it if we don't agree. So I would wait for the proceedings to take the court to make its rulings. Then I will have my comments on the ruling.
Okay, so Dominic, now here. So you say you are being stampeded.
Yes.
But you know that on the day when they made this decision, that day was actually the 21st day after the petition was served.
Yes.
Which means that, according to the timelines, that day was the day that the trial should have been ending.
You see,
are you not prolonging matters?
There is a certain misperception, or let's say misconception, about CR99 that we need to, dispel. And that is that, you see, this whole idea that the trial has to end in 42 days has been sold to the public, as if to say that on a day-by-day basis, you have to be counting. But if you look at the CI itself, the second schedule actually says that you begin in January and you end in March.
That's right.
If it were the case that you were supposed to just count on a day-by-day basis, all right, then it would have meant that we can actually do this, before March. And the lawmaker was not stupid, or acting irrationally when they put March here. It means that actual courtroom activity must not last more than 42 days. All right? But by all means, by the end of March, we should terminate proceedings. So if you give us 5 days for case management, and then on the second day, because we had brought the application for interrogatories, so they said we had eaten into the first day of case management. So on the second day, we expected the usual practices and conventions relating to case management conferences to take place, where both parties and their lawyers would be consulted by the court. How many documents are you going to be filing? What is the nature of the documents? Are they electronic and so on? How many witnesses are you going to call? How many days are you going to take for purposes of, cross-examination and so on and so forth?
In this case, the days to take is known. There are 6 days for the trial.
No, yes. but there are 6 days. But between the Electoral Commission and us, all right, are we taking 1 day and they are taking 2 days or 3 days and so on? So that is what it is, why it is called Case Management Conference.
Okay.
So
does it make any difference that when you interact with a judge in case management, it's not everything you say that is taking?
Oh no.
So it is possible,
yes,
and we face it in court.
Yes.
You have a discussion with the judge over the thing, but in the end, it's how the judge feels is the best.
That is so.
That may be upheld.
You see, because adjudication is a deliberative.
So does it make a difference?
It does make a difference in the sense that, okay, yes, when I'm consulted and the judge, based upon my responses, says that, look, I disagree with you. I don't think you should take 2 days to do cross-examination. I think you 1 day can do your cross-examination. That alone is an inherent, part of the process of case management and adjudication. All right. For you to not consult me and come out, even in the High Court, you have done applications for directions before. When has a judge just come out, read your issues to you and told you to file your witness statement tomorrow? Has that ever happened?
But even in the Supreme Court, we know that both parties could agree outside before the court. You agree on the issues. It is when you can't agree that the court will intervene.
That is so.
Right.
So, and Gary,
just as it's happened in 2013, Gary, just as it happened in 2013, the issues that were brought were many. The parties couldn't agree. Now the judges came in and they narrowed the issues down to 2, whether there were irregularities and so on and so forth, and if there were, whether they impacted the elections. How much of a change in the law or procedure has happened by what they have done, if any?
Samson, I disagree with you when you suggest that, or you put the question that there was an imposition or there was no contribution on the side of the petitioner into the memorandum of issues that were filed before the court.
No, I said that, not something.
I believe my understanding was that the petitioner had filed their issues in the morning. Is that not correct?
That's exactly what I said, that they took their issues.
Yes, so they're taking the
alone, without the lawyers' involvement. That's what happened.
Yes, something, but you filed your issues. You see, what was left for the court to do? The interrogatories had already been dismissed the day before. Was there any application before the court on the morning that the court didn't deal with on the morning? No. Exactly. So it has been dismissed.
No, there were other preliminary matters, such as our request to inspect documents and so on. And then the request, to admit facts.
But those requests, were they before the court on the morning?
No, they had been filed. So that would have been part of the case management.
Yeah, but
that would have been part of the case management.
Were they before the court at the time when they were taking down the issues?
They are before the court.
Well, my understanding was
if they were not, how could they have given a roadmap saying we are going to deal with this day, that date?
My understanding was that there was nothing before the court, and if you look at
the court didn't say that. So let's
look at the proceedings. Please, let's not argue.
Don't mislead the public.
When we watch the television, okay, I heard one justice saying that, as it stands now, there is nothing before us. What was before us? What we dismissed yesterday, and it was addressing,
And Tajushikata pointed out to them that we have these procedures.
That was before they came out with the roadmap.
Yeah.
You see,
correct?
Samson.
Yeah.
I would defer to what we all saw about the proceedings. What was before the court, if indeed it was filed before the court on the docket, I wouldn't see.
But you are aware, as part of the legal...
I wouldn't see.
No, but the inherent question I'm asking you is, if you say they are unaware, but at the time they brought out the roadmap, if you are unaware, you don't say, I will deal with your application the next day or the other day. You must be aware before you say, I'll deal with it the next day.
Samson, be that as it may.
Yeah, but the substantive question was, is this standard? Because that's the impression being given, that it doesn't happen. That the judges will take your memorandum of issues without your input and then impose the directions.
Without which input? The directions have been, you have filed the direction already, and the court has set your issues down for trial. So what input again are you talking about here? That's the question I'm asking.
So there's nothing wrong with that?
There's nothing wrong with it. You filed your issues for directions. And the issues... Doc, wait a minute. The issue has been filed by both sides. The petitioner has filed the issues, the respondent has filed the issues. They put it together as memorandum of issues, and they come and read it to you, and they give you a roadmap. Now, you say, subsequent to that, you say, look, we have filed an application for review. At that time, At that time, the application for stay had not been filed. And they said, well, it doesn't bind us. It doesn't tie our hands from proceeding with the matter. Now you say you are going to file application for stay of proceedings.
Yes.
No problem. So let the court go and deal with it. We are not judges here. Go and deal with the application for stay and then decide one way or the other. And then we can all know the direction that the case will span. But you see something, the point I want to make, there is a certain semblance out there that, oh, we have a case in court. That case is an iron cast case. But you are trying to, more or less,
railroad,
stampede our attempt to vindicate our grievances before the court. That impression is wrong. You know why it is wrong? The trial has not commenced. The trial has not commenced. Now, issues have not been filed, set down, file a witness statement, which is substantially not different from what is contained in your petition.
No. I mean, lawyers do that, but they are different.
Do you realize that? Do you realize that? Do you realize that, for example, the respondents, they have preliminary legal objection.
Yes.
Their desire would have been that the preliminary legal objection will be determined first.
Yes. Exactly.
So that if it ends up terminating your case, they won't waste their time in the trial.
Yes.
They have been asked to file their processes, and that the preliminary legal objection will be determined and incorporated in the judgment.
Yes.
They clearly are not happy, but they have complied. Oh, why can't you do the same?
Well, that is a different kettle of fish altogether, substantively. And that is because, you see, the Supreme Court itself has ruled on a number of occasions that when it comes to constitutional matters, okay, they are hesitant to dispose of matters, okay, I mean, through the raising of preliminary objections. And they have always said that you should incorporate it into your case, your statement of case, all right, to form part of your judgment. I mean, your this in a...
You agree that precedent is there?
That precedent is there.
You agree? Gary, you agree?
You're not certain.
I'm not certain, but you see, like you rightly pointed out, we will have wished that matter is determined first before even you can go into the matter. But the justices in their wisdom have decided that they will incorporate it as part of the final judgment.
Yes.
So it's okay. We're gonna abide by it, and actually, we have actually filed our witness statements.
Our fundamental agreement. I saw your witness statements. I've actually read them. My fundamental disagreement with you, Gary, respectfully, is the fact that you have reduced case management or pre-trial to just a determination of the issues, that have been filed by the...
All right. Thank you very much, gentlemen. Unfortunately, time is run out on us. My guests have been Dr. Dominic Ayine, who is MP Bolga East. That's my constituency. I can't get it wrong. Bolga East, and member of the legal team of the John Mahama team. Clara is on Zoom with us. Clara Berry Kaseti is lawyer and lecturer, University of Ghana Law School. Dr. Okoboy joined us earlier, former Deputy Minister of Health and member New Patriotic Party Communications team. Kwame Sapong Asiedu, pharmacist and fellow Ghana Center for Democratic Development, also joined us. And Gary Nemako Mafo, member Legal and Constitutional Committee of the New Patriotic Party. He's got a lot of work this period, right? A lot of legal battles.
Yeah.
I'm Samson Ladia. Thank you all so very much for your company. See you again next week, God willing, with another edition. Wear your mask and sanitize.